Good morning. I apologize.
So no reason. You're good.
Good morning. May it please the court. My name is Jason Foreman. I represent the appellant in this matter. I would respectfully ask for 5 minutes for rebuttal.
Sure.
As the court knows, the appellant was convicted of misdemeanor battery and lewd molestation involving the niece of his business partner. The battery offense took place in the appellant's kitchen during his daughter's birthday party, where he allegedly pulled a t-shirt of the 11-year-old girl, looked down her shirt, and indicated that he could see her breasts. The molestation offense took place while the appellant was driving the girl home from the birthday party, where the victim claimed that he reached out, put her hand in his shirt, and touched her breast while they were driving. And of course, because she was 11 years old, he's serving a 25-year mandatory sentence. Like many of these cases, the issues involved in this case include Williams rule evidence, a substantial amount of child hearsay evidence, improper comments in closing argument, as well as a host of other errors, some preserved and some admittedly unpreserved. And before I specifically address the issues, I just want to point out that this was a hotly contested case. The credibility of the defendant and the victim were critical. There were no eyewitnesses, no forensic evidence, no DNA, and the defendant always denied that he was guilty. And with that background, I'd like to talk about the Williams rule evidence that was admitted in this case. Aside from the lack of similarity that should have, which the court should have excluded the evidence based upon, the deposition of the Williams rule witness was actually used instead.
Does the strikingly similar standard apply to prior acts of child molestation at all? I know I infer from your briefs and the case law that similarity, is pertinent depending on what the use of the similar act evidence is. But is it apply at all to prior acts of child molestation in the case law?
When it's dealing with corroboration, it doesn't have to be strikingly similar. However, the case law says the less similar, the less relevant. In my brief, I did in the very last subsection, I talked about absence of mistake.
But you can't categorically exclude this evidence because it's not similar when it comes to prior acts of child molestation. Isn't that right?
That's correct. My argument is that language, the absence of mistake, should not have been allowed to have been presented in the Williams rule instruction. It should have just been for corroboration. And they argued absence of mistake, the prosecutor did. But Your Honor's right. It doesn't have to be strikingly similar to be used in a case like this, but it does have to be similar. And in this particular case, the less similar, the less relevant. The less similar, the more prejudicial it is under 403 analysis. And in this particular case, the judge issued an order 3 months after trial, making findings of similarity, which they weren't even similar. And specifically, the age, the Williams rule victim was 15. The victim in this case was 11. That's a 4-year difference. The case.
What are the most supportive cases for that age difference being fatal to the admissibility of the evidence?
The case I cited in my brief, Your Honor, is a 4TCA case called Pulcini. And in that particular case, it was a 12-year-old and a 16-year-old. And they said that was a dissimilarity, not a similarity. And that's the same.
What was the use of the similar or of the Williams rule evidence in that case?
I don't recall, Your Honor. I apologize.
Oh, that's right.
I'll have to defer to the case. What's that?
Because I don't remember either. So
okay. I did cite in my brief, and I apologize. I just quoted that case for basically the age difference. And it was the same thing. It was for the same type of, they were trying to corroborate sexual activity. So it was for the same purpose. I just don't know the particulars of that case, and I do apologize.
Well, I mean, it can be the same crime, but there's lots of different purposes here. One of the purposes the state advances is that it's and maybe you'll get into that, your misgivings about that, but it is absence of mistake, because the defense, the appellant's defense was, oh, no, I didn't intend to actually molest, although I may have had contact with the victim. It was unintentional. It was not intentional that it be sexual. Doesn't that fit within the absence of mistake? Doesn't that give rise to at least the potential for admissibility of evidence of lack of mistake?
Yes, but the case law specifically says absence of mistake, you need strikingly similar,
That's what
or
I'm asking. That strikingly similar requirement. There's lots of different types of cases in which Williams rule evidence could be admitted. There's this one is child molestation. It could have been, I don't know what other, I can't think off the top of my head of a scenario, but other crimes. But even if the purpose is absence of mistake, is the striking similarity requirement applicable in child molestation cases, even for that purpose?
okay. I think I understand, Your Honor. The evidence was admissible, but what was not admissible is the portion of the Williams rule instruction where the judge actually tells the jury that they can consider this evidence for absence of mistake. So that's the part that I'm arguing that is improper. Is the evidence admissible under the corroborating portion of it? Yes. But you can't instruct the jury that they can consider it for absence of a mistake, and the state can't make that argument. You can consider it for absence of mistake because it was not strikingly similar. But it was admissible under the other aspect of the Williams rule regarding whether or not corroborate sexual activity. So I hope that answered Your Honor's question.
I understand your position.
Okay. And of course, my initial threshold argument is with the Williams rule evidence is that the deposition of the Williams rule victim was admitted in lieu of her live testimony.
Now, what is there any case that says that at a pre-trial hearing on the admissibility of evidence that it is reversible error for the court to consider a deposition in lieu of live testimony? We're not talking about a confrontation problem here, right? Because there was a right to confront at the deposition at the time the testimony was originally taken, and there was a right to confront at trial when that victim, that witness actually was faced by the accused.
Well, the Simmons, I don't have a case that says that, Your Honor, but the Simmons case that was relied on by the state and what was used to convince the court to allow this testimony in lieu of this deposition in lieu of live testimony is different. In that particular case, they used the charged victim's, the victim in the Penny case, her deposition. And all over the Simmons case, they kept talking about the fact that the Williams rule witness actually testified at the hearing and was subject to cross-examination. And they even italicized different language in the case to highlight the fact that there was a difference between the victim of the charged crime and the victim of the Williams rule crime. So in Simmons' case, it specifically talks about the charged crime victim, not the Williams rule victim. Here, the Williams rule victim was available. Prosecutor didn't want to present her because she was nervous.
Again, let me ask you, let me say real quick too, because I want to clarify something else. You in the briefing, I think established or at least cast quite considerable amount of doubt on the idea that you stipulated to use of the deposition for JW, but it's one thing to say you didn't stipulate, but it's another thing you're not actually saying you objected specifically regarding JW either, or am I incorrect?
No, I specifically say that he has a standing objection on page 424 of the record where he talks about the not using the deposition, objecting to it. He doesn't say I object to the use of JW's deposition. The record's not that clear, but in the context of everything, the only thing he stipulated to was the 9-year-old other Williams rule, the 9-year-old child hearsay's testimony, not this particular witness.
Yeah.
Yes, that was OW, not JW. But aside from that threshold requirement, the conduct wasn't even similar. If you look at the trial court in its order found that they were both alone, but we know that's not true. In the vehicle, OW, the listed victim, was alone in the car, while the Williams rule victim was not alone because his minor children were there too. And there's a case in my brief that cites specifically to that. The court also tries to justify the similarity by saying that there were some sort of custodial relationship between JW and the appellant, but that's not true. She was watching his kids where the listed victim, OW, in the car was alone with the appellant. That is a custodial arrangement. And there's other factors that I listed in my brief too to demonstrate that it was dissimilar. This wasn't similar at all. The only thing is it's basically they were both young girls and it involved him. I mean, that was it. The conduct's different. The body parts that were touched are different. Everything was different.
Wasn't there a similarity in the least as it was alleged by the state, a kind of a pretextual, depending on how the jury looked at it, pretextual strategy to have the child alone with him in both scenarios? One, there was testimony that he said, well, no, I know he called, there's debated testimony whether he actually called the uncle, but what he said to the alleged victim is, well, your uncle's not coming and you're with me and maybe we should stay here. And the other one, that was at the gym, I guess, right? And then the other one, the actual crime was similar in that there was sort of it can be perceived as like a pretextual establishment by the defendant to show the victim that, well, she's alone and she's stuck with him for some duration. Is that a similarity in the two?
I respectfully disagree that there was any sort of pretextual nature like that. In the vehicle, that could be said perhaps if he took her in the car and drove her home. But the only reason why he was alone with her is because her father was taking care of his drunk girlfriend. So it was just by happenstance that he was the only one there. And he said, hey, your dad's going to be back. I don't know when he's going to be back. You could stay here. Don't worry about it. But he may be back. I don't know exactly when he's going to be back. And she was texting him and then he did show up. So I don't think that there was any similarity at all between what happened in the gym and what happened in the vehicle. It's totally different. The duration's different. The location and the time's different. One's at day, one's in the middle of the night. I just think everything about this is different other than that the girls were related. It involved the appellant and they were both young girls. I think everything's different. And of course, the admission of this Williams Rule testimony certainly wasn't harmless. I mean, the state relied on it in its closing argument. Even the fact that, the defendant indicated that he didn't believe either girl was telling the truth, that was actually used as well as closing argument. As far as the other issue I'd like to address is the child hearsay issue, of course. Certainly the record isn't a pillar of clarity regarding objections. I, of course, acknowledge that counsel did not object to the lack of factual findings, but I would respectfully submit that that was not required for two reasons. One, the trial court indicated that it was going to write an order, which the court did, of course, 3 months after trial. So I would respectfully submit that no objection was required. And of course, under the Hopkins case, I would suggest that if you object to the reliability, that necessarily entails a sufficiency of the factual findings. Now, of course, this was prejudicial in this case because the trial court, in its order 3 months after trial, which of course was unbeknownst to defense counsel to the order was rendered, did not consider the deposition at the child hearsay when making a determination whether a child hearsay was reliable, did not consider the deposition of the listed victim, where she said, my memory's bad. I don't know if he actually touched me, touched my breast, which obviously
the court didn't consider that.
Excuse me?
How do we know that the court didn't consider it?
Because in the specific, in the court specific order, he specifically states what he did consider, and that was not addressed in the order.
Not how we review, trial court orders, you say, well, you listed a bunch of things that you considered, and if you leave one out, that is proof positive that you didn't consider something that you should have, and therefore that's reversible error. What's the doctrine or case law that it shows that that's reversible error?
Well, there's a Latin phrase, which I'll totally butcher, the exclusio.
Exclusio ulterius. But
of course, Judge Atkinson knows how to pronounce that phrase.
Your Honor, but I did cite a case in my brief. I think it's called Hayes, where it says what the court means what it says. In this particular, in the order, it specifically says that by stipulation, the court reviewed the recorded testimony of the 9-year-old girl and also the CPT interviewing containing her statements. But that's the whole problem here is if the judge doesn't articulate the factual findings, which would necessarily entail the inconsistency in her deposition, then the only thing we can go by is the court's order. It says, this is what I considered in addition to the live testimony. So by specifically not mentioning her deposition and without even mentioning any inconsistencies, I think the order is pretty clear that the judge did not consider her deposition. That's the only way that we could figure this out. defense counsel did ask a couple of times on the record what were the statements that were permissible, and the judge kept deferring to his order, and then eventually just said, I will, just look at the state's notice. That will give you an idea of what was admissible.
Hey, Mr. Foreman, you're down to 5 minutes. Use them as you please.
Okay, I would like to reserve the rest for rebuttal if that's okay.
Sure. Ms. Richards, you're up.
Good morning, Your Honors. Cynthia Richards from the Attorney General's Office. I represent the state in this case. I'm going to dive in. You've been briefed on the facts in this case. To the first issue, we're talking about the Williams rule and the lack of similarity. Judge Atkinson, to your point, the court actually was very specific about his order and the similarity. In fact, the quote from the court was, upon listening to the testimony by JW concerning this alleged conduct, the court was convinced by clear and convincing evidence, not only did the act occur as described, it was done with salacious intent. The act committed contemporaneously with the suggestive comments. And I think that was one of the things that really stuck with the court. When you take this 15-year-old child, JW was at the time, and you have a grown man on his knees kneeling in front of her, rubbing her upper thigh for 20 minutes, an extended period of time, all the while telling her, well, I don't know if your uncle's coming. I guess you have to spend the night with me. And the JW telling the court, I was nervous. I was very uncomfortable with it. The appellant, she said the appellant didn't break eye contact with me. So the totality of the circumstances, and to your point, Judge Atkinson, yes, it was, they were alone. They were in the defendant's house at that time. There is a lot of similarity between her cousin OW. There was a guise to isolate and control, whether it was OW or JW. There was the touching. There was telling both. To JW, the defendant had said to her that, I don't know if your uncle's coming, he's dealing with his drunk girlfriend. You might have to spend the night with me. And telling OW at the time, I tried to call your uncle. He's not coming back to get you. It's instilling that thought in both little girls' heads that they are now on their own and have been abandoned by their family. And he's suddenly their caretaker and in charge of them. The difference, I think, between discussing the case defense brought up between a 12 and a 16-year-old, just by the sheer age, the distinguishing factors of that case is 16. Under 16 is statutory. This is an 11 and a 15-year-old. They're family members. Like I said, they were both isolated. There's numerous similarities. And even under this, as you said, Judge Simmons v. State, dissimilarities aren't fatal. They seem to be a result of the differences in opportunities, which is what the court in Simmons said. And that's what we have here. I mean, whether it was the battery that occurred in the kitchen to OW, she was isolated. She was in the kitchen alone with them. The defendant chose his opportunities. And with JW, yes, his two younger children were there, but the testimony was, including by the appellant, that they were asleep. They were, I believe, 4 and 6 at the time, and they were asleep, so they were not aware of what was going on or what appellant was doing to JW while she was in his house. And regardless, we also discussed whether there was an objection. There was no objection. That's a fact of this. But defense not only did not object, they actively agreed in the hearing. And I know the defense says, oh, no, we were referring to the 9-year-old girl's deposition. They were fine with that. But there was in the record, you'll see a discussion between defense, state, and the court where they're discussing, because JW was available and did testify at the hearing. And the state had asked the defense, well, we did not prep her for the evidence do you mind if we rely on the deposition for that? And the defense actively said that's fine, because at the time, if you look at what the defense was concerned about, they were concerned about the similar fact evidence of the appellant's former stepdaughter, MB, because that was 10 times as damning as the similar fact evidence from JW. And in fact, defense counsel said that their concern was the similar fact evidence of MB. And that's a non-issue because it was denied by the court and not used at trial. But they did say that they had no problem using the deposition because the child JW had not been prepped. That wasn't their concern at the hearing. So not only was it not objected to, they did agree to use the depo for the similar fact evidence in that case. And, you know, regardless of that, it would have been harmless error anyway, because for it to be anything other than harmless, then the testimony at JW at trial would have to absolutely vitiate. There's no way the jury could have found appellant guilty if JW had not testified. And that's simply not a fact. When OW, the 11-year-old victim herself.
Let me ask you this before we get to that. Is it error at all? Even if it was objected to, is it error at all?
It's not error at all because
I don't want to hear live testimony. I just want to decide whether it's admissible based on this cold transcript. Is that reversible error? It's just
it's not reversible error. It's, Your Honor, it is a pretrial hearing. Things are admissible in the pretrial hearing. There's hearsay, everything else that may or may not be admissible at trial. But this is not error of any kind. Not only was it not objected to, not only was it actively agreed to by defense, and at trial it would have been harmless, but I can find no case law saying why the use of a deposition for JW at the pretrial hearing is an error at all. The courts rely on that, on depositions in pretrial hearings all the time. And in this case, there's just no error of any kind. And moving on, unless there's any other questions.
What were we going to move on to? Go ahead.
To the child hearsay. In the court's order.
And by the way, opposing counsel didn't have an opportunity. He'll have the last word. So I was going to feel bad about raising it. You raised it. So go ahead.
Well, Your Honor, this is on the child hearsay, which we did address. It is unpreserved and thereby waived. So there was no objection to this. And when defense says there were no factual findings, the court order was actually very specific. And I know it was not part of the record, but there were 3 pretrial hearings on these issues. The last one, the Friday before trial, at which point the judge said, I'm sending you and defense counsel to the state an email with my findings Sunday night, which he did. Before trial Monday morning, on the record, the judge discussed with defense and the state what his order was going to be. In fact, defense counsel said, so what exactly are you admitting? And the judge at the time before trial said, the way it was spelled out on the defense's motion for child hearsay, I'm allowing admission of everything the state requested. Sorry, I said defense. The state's motion for admission, I'm allowing all of that in. So, and like I said, the first 2 hearings was in November. Now we're talking the end of January, beginning of February for trial. There is no prejudice to defense. They had known all along what the child hearsay issues were. There were deposition takens. There were video statements taken. They had ample time to prepare. JW and OW both testified. Both were crossed. In fact, defense crossed the victim OW with her deposition transcript in court several times. And so, I mean, not only is this unpreserved, it's not an error at all. Even if it were, it would still be harmless because the defense did have every legal opportunity to prepare. They had every legal opportunity to cross, which they did, the victim and JW on the stand at trial.
Assuming that procedural issue is not a problem, which what about the cumulative nature of the testimony? As that's the part that opposing counsel has time. It's not, didn't have an opportunity to talk about, but they'll have time to rebut. You know,
I understand, yeah.
Clause is not nothing.
Well, it's not cumulative because the child hearsay witnesses, they're pieces of a puzzle and it's a timeline. For example, if you want to take it in order, OW immediately told her grandmother. That's the first adult she saw. Within minutes, she walks in the house. She's very shaky. She's scared. She tells her grandmother. Well, it's a spontaneous statement, first of all, but it shows the veracity of her statement. There was no time to prepare. That's the first statement. It also shows that when the grandmother testified, the effect that the abuse that just happened had on the child's demeanor. The child was afraid enough to say, please don't tell my parents. She was scared she was in trouble. All of this is completely admissible evidence. And you want to move on to cumulative. Like I said, it's puzzle pieces of a timeline because you have to go from telling grandmother to how we get to being at a police station 3 days later. And for that, you need the testimony of the little girl at the pool party, her friend who she told, who immediately went, oh, this is bad. I have to tell an adult, who told her aunt, who told the parents. Now we're back to, okay, now the parents know. We go to the police station the next day.
You're right now. It seems like you're arguing that this evidence was admissible because it was necessary to move the story along. Now,
well, it absolutely is.
Let me ask you this: is it admissible for the purpose of lending credibility to the victim's story by virtue of her having, shortly after the alleged incident, told the story multiple times to multiple people, and the facts were consistent with her current story? Is that a permissible use?
It is a permissible use, but that was not the only use of the testimony.
Let's say hypothetically, so let's say, I mean, you're making a good case for the other uses, and you're making the case that each individual witness had peculiarities that made them unique, and that would argue against the cumulative argument. But what if really the only real probative value is the similarity with their story told contemporaneously or close thereto and their story now? Is there a point where while that's probative, it becomes too probative and becomes prejudicial?
Hypothetically, if the state put up 7 witnesses and their only testimony was reiteration of the exact same paragraph story, I would have to agree that no, if that were the only purpose of somebody testifying, it would be repetitive and it would be cumulative. But that's not what happened in this case. And in fact, if you look under the 980323, and the court specifically said several times, he was limiting the discussion by any of the child hearsay witnesses only to the description of the sexual abuse. But these witnesses, it's almost, the defense almost makes it sound like, were they not there to sort of say what OW had said to them, they would not have testified. That's not actually true. In fact, if you look at the mother and father and grandmother's testimony, they all retelling the story that OW told them was such a minor part of their testimony. Like the mother talked about the child's reaction, cutting her hair twice, wanting security in the house, being afraid. They talked about her hearing aids, her ADD medicine. Their testimony was not merely corroborative of the story the victim told. In fact, that was only a minor part of it. And the minor part of it was just a basis of explaining how their 11-year-old child behavior changed so dramatically from the abuse that she suffered. And I mean, and we're talking about the defense.
Can we go back though, that I'm not sure whether I buy that it was a minor part. It was pretty major to say, hey, she told the same story about the act for which this gentleman is accused, of which he's accused. But what was your answer again to my question? Is that a permissible use? Is that probative and relevant, and but also permissible, meaning not per se prejudicial to say, what if there was no, what if it was just one witness and there was just no suggestion at all about her demeanor? Witness just said, yeah, this victim told me, explain to me the facts of the alleged crime, and I'm here to testify to that, so that when she testifies on the stand today, it's the same, and therefore that's probative of her, of the truthfulness of her statement.
It is permissible, Your Honor. And if you look at State v. Townsend, the 1994 Florida Supreme case, it's the court held there, the court may consider mental, physical age, maturity of child, nature, duration of the abuse or offense, relationship, the reliability of the assertion, the reliability of the child victim, and any other factor that it deems appropriate and necessary. And going through.
If that's probative in a permissible way, so to speak, relevant in a way that's not per se on a one witness basis excludable, then how many of those does it take under the case law to become cumulative in a way that is presumed harmful or suspected as harmful?
Well, I mean, there's no hard and fast number. I can't say, well, 4 people or 8 people. There's no number. You have to look at the totality of the circumstances, each individual person's testimony, and does it add something to the overall timeline and facts of the case, or is it there only for repetitive cumulative testimony? And in this case, the child hearsay people that testified, each individual one added additional components to the case. So I can't tell you there's no exact number, but in this particular case, each of the witnesses that testified in the child hearsay added something additional, added something probative, added something that is admissible under any standard in this case, let alone the fact that this was never objected to and deemed waived. I mean, it was admitted that it was never objected to and therefore is not even up for review on appeal. I mean, the defense also brought up Hopkins v. State. And that's distinguishable because in this case, well, first of all, it's not a closed circuit TV case, but the defense argued that it was cumulative and not the reliability nature of the testimony. In fact, there was a discussion with the court where the court said, well, you're not talking about the reliability of OW's statement. You're just talking about how many people you put on the stand to discuss the child hearsay issues. So that's completely dissimilar from the Hopkins v. State case. And the court did conduct the necessary factual analysis and wrote it out in its order. But before the order, as I was saying, there was the email, there was the pretrial discussion with the court. This had been discussed in 3 pretrial hearings and the morning of court ad nauseum. This was not a surprise, and this had been dealt with, and not once during all of that time did defense object to this. So this should not even be up for review here today. And I know defense didn't get into it, but just to briefly mention issue 3, the mentioning child molestation. This was not an issue. It was also not preserved. Nobody objected to it. In fact, during closing arguments, the only objections really came from the state, from the defense's, telling the jury that, from what he sees, it's their duty not to convict, and the child was a liar, and all of these, impermissible arguments from the defense. And there was no statement made, either opening or closing argument by the state, that could be said to reach the level of fundamental error to change the direction of the trial. So this is also unpreserved and a non-issue. And therefore, by the cumulative nature of all four of these issues being unpreserved and non-issues, basically, this should be, we ask that you affirm the judgment and sentence. And unless do any of your honors have any further questions for me, I will then rely on my brief and ask that you affirm. Thank you for your time.
Okay, that's great, Ms. Richards. Okay, Mr. Foreman, you're up for your rebuttal.
Thank you, Your Honor. First, I'd like to address the child hearsay. And I think what Judge Atkinson was getting at was my position is not that the witnesses could not have testified. They certainly had value, but their child hearsay component of their testimony was cumulative. So certainly they could have testified, as Ms. Richards suggests, to provide a timeline. They just all could not have testified regarding the child hearsay. It was seven.
Can we start with the question I proposed to opposing counsel? Would you agree that without consideration of the number of witnesses, let's for hypothetical purposes say it's one witness, that a permissible purpose of child hearsay testimony can be merely the similarity of the story that the victim told near the time of the alleged crime, near in time, shortly after the alleged crime, and to the child's later accounts of the crime, most particularly on the stand at trial? Is that a permissible use? In other words, that's probative of the witness's credibility, because at the time, shortly after the incident, her story was similar to that which was recounted by her sometime later at trial. Is that a permissible use?
Okay, I'd like to answer the second part first, because for me, I think that's easier. There was no allegation of recent fabrication that would allow consistent statements to come in. This was the defendant's position was it just never happened the way she said it from the get-go. As far as the first component of Your Honor's question, is it permissible to demonstrate, I guess, consistency or I guess to demonstrate veracity of her statement? I mean, I guess that's what the purpose of the child hearsay is, to corroborate what they're saying.
If he told others the same story, it lends credibility to the story she's telling them. Is that a permissible use?
Yes. Well, I'm going to say no, because the problem is when you have parade in an avalanche of witnesses as
Well, I haven't gotten there yet.
fair
My
enough.
next question is if that's probative and, not per se prejudicial, everything's probative the state puts on presumably because they're going to waste their time with stuff that doesn't hurt the defense. But is that a permissible use on a one witness basis? And if so, how many witnesses is too many? And my other question is maybe too philosophical for an oral argument, so you can ignore it. But if it's probative, then the more the merrier. Then why isn't it just more probative? And why, at what point, and why does it become prejudicial?
Well,
What is your rationale for why it's prejudicial? Well, let's go backwards since we have limited time. What is your rationale for why the volume of witnesses saying the same thing is prejudicial?
okay. Based on the case law I presented to the court,
Uh-huh.
it's prejudicial because there's an avalanche of consistent statements that basically just conveys to the jury, the more they hear it, it must be true. Just because she told, in this particular case, 7 people came in and testified as to Williams' rule.
But if they're recounting it in a similar manner to one, why does that suddenly become prejudicial? Doesn't it actually just make it more probative in the same way that's permissible? In other words,
No,
it's
because I mean-
permissible to say she's credible because she's told the same story then and now. So doesn't it make it more probative?
No, because under 403, at some point it's cumulative and it becomes harmful that they're not just judging the credibility, that basically just because she told 10 people.
Oh, I'm sorry, I interrupted. You're about to say, go on.
I apologize, Your Honor. Just because she told 10 people doesn't mean it's true. And that's the problem is now it goes right to the heart of the case for credibility.
Because she told one person, it does lend credibility, but because she told 10 people, that I know I'm getting a little philosophical, but tell me why, in practical terms, the jury is confused or the jury is hanging its hat on something it shouldn't.
Well, again, the best way I can answer, and I'm not doing an adequate job, and I apologize for that,
True.
is the more they hear it, does not necessarily mean that it definitely happened. It just means that she told all these different people. And the problem is then the jury takes that as, all right, she must have been telling the truth because she told 10 different people. And that's what the case law says you cannot do.
But if it's permissible for the jury to draw the inference that if you told one other person, she must be telling the truth, then why is it impermissible for the jury to draw the inference that, well, it must be, she told 10 people, so it's more likely to be true?
The only thing I could do, Your Honor, is perhaps defer you to my brief, and I apologize for that. I think I articulated a little bit better as far as the cumulative nature of it. But in this particular case, we have a parading of all these witnesses. So at some point, it becomes overly prejudicial under a 403 analysis. And what it does, it just has a significant reinforcing effect in the minds of the jury regarding the child's credibility. That's what the case law says.
And then again, by the way, just to be kind, I mean, I'm not sure the case law answers my question all that well either, but I think it is pertinent for us for if we're going to say it's wrong and say it's harmful, you know what? There's a case, the Pardo versus State, and it talks about actually a little more specific. It says that it may cause the jury to evaluate the credibility of the victim's statement based on the integrity, reputation, or qualifications of the adult or professional child hearsay witness. So that sounds deleterious and unduly prejudicial. In other words, they shouldn't be judging the credibility of these hearsay witnesses just because it's, oh, he's a cop, so therefore it must be true because she told a cop. But in other words, what other than the fact that she told other people and she told too many other people is prejudicial to your client?
Well, and if you look at their stories too, each witness varies a little bit as far as what they say. That doesn't necessarily mean that OW was not consistent with what she said, but all the different witnesses have different components of what the child said. They all talk about how the appellant touched her breasts. But again, I don't know the specific, I can't answer that question. I apologize. You stumped me. Maybe I should be able to answer that. But if you look at the cumulative nature of all of that testimony in conjunction with everything else that went on in the trial, the closing argument where they talk about 9/11, and this was the child's 9/11, clearly improper. Going to the closing argument, in the prosecutor's initial closing argument, where he informs the jury how you can't rationalize behavior. No one in their right mind would do this to this victim. Nobody that is rational is going to do this. We know child molesters are out there and they do it anyway. This is highly prejudicial. The defendant testified that he had PTSD. He was a wounded Iraqi veteran. These comments.
Yeah, let me tell you that you and Judge Atkinson have used up your time, Mr. Foreman.
Okay.
So you probably ought to just close at this point.
Very good. I would just respectfully submit that based on the totality of the record, with all the allegations and discussions and labeling of child molestation, of the 911, of all the errors in my last argument, asking if the child victims lied, everything in this particular case cumulatively deprived the appellant of a fair trial. We ask that a new trial be awarded.
Thank you very much. In order to leave our virtual courtroom space, you need to click the leave button in the lower right-hand corner of your